between Mr. Gawan Bitrus Dom and Boson PFC. My Lord, parties absent.
Yes, appearances, please.
Most respectfully, my Lord, L.J. Lagan, I appear for the claimant, applicant as well.
Yes. Yes, any appearance for the defense? They are not represented?
Lord, it appears so.
I hope the hearing notice was served on them too. Yeah. Registry?
Yes, my Lord.
Was the hearing notice served on them?
Yes, my Lord.
Yes.
My Lord, the matter actually comes up today for adoption of our final written addresses. We had also filed a motion, very harmless motion to amend our statement of fact, particularly the relief section, just to ask for a particular relief in line with the evidence.
Yeah, I can. Okay. Somebody is saying, my Lord, are you for the defendants, please?
Yes, my Lord, I'm so sorry. The network went off, so I had to quickly switch to another network.
Okay. The matter is for adoption of address. We have also filed a motion for amendment. Yes, at this point, what's your name, sir?
My Lord, may it please this honorable court, I am S.A. Ibrahim.
Yes.
My humble appearance is for the defendants.
Yes, as you've just heard, the claimant is stating that they have a motion for amendment.
My Lord, we filed a counter to that particular motion for amendments, together with a written address.
Yes, Mr. Lagan, are you ready to move your application?
My Lord, we are very much ready. We are surprised at the counter because honestly, it is highly misconceived. Basically, we are not tampering with pleadings in any way. All we are asking in the application is to
they filed the counter. Can you just move your application? Let them argue their counter too.
Very, very well, my Lord. The application is dated and filed 21st day of June, 2022.
What day?
21st June,
yes.
2022.
Yes.
My Lord, the reliefs are as contained in the first of the motion paper. Is supported by an affidavit of 5 paragraphs.
Yes.
We also filed a written address dated and filed the same 21st day of June, 2022.
Yes.
My Lord, we rely on all the amendments contained in the affidavit, and we also adopt the written address. As our submission in support of this application.
Yes.
My Lord, may we just add that the counter affidavit filed against the application is the content therein and the submission of the learned counsel in his address is highly misconceived. It's highly misconceived. As this application does not in any way intends to overreach the defendant in any way.
It does not in any way what?
As it will not and does not intend to overreach the defendant in any way.
Yes.
But the only relief the application seeks is to specifically ask for a particular head of claim, which is not in his original statement of fact.
Okay.
To fall in line with the evidence before the court.
Yeah, you've argued your application. You are just reacting to the counter.
Well,
yeah, I've heard you. You know, we're on network. We have to be fast if you've made your submission clear. So let's leave it at that.
Very well, my lord. Because just to make the point that there wouldn't be nothing has been changed on the pleadings. Nothing at all. We have not changed anything.
Except for the relief that you had it.
It's just for the relief. We're just
that's what's changed, and that's what they are opposing.
Well, no, they cannot stop us from asking anything from the court. It is for the
court. Let's hear them, please.
To look at it, whether we're entitled to it or not. It's not for them to say we cannot ask for something before the court. That is unheard of. We must humbly ask my lord to grant this application. We're ready to adopt our address. It's already before the court. If my lord so desires. Thank you.
Yes, thank you. Mr. Ibrahim.
Yes, my lord. In opposition to the said motion on notice, the defendant has filed a counter affidavit dated of 5 paragraphs, my lord, dated 28th day of June and filed on the same date.
Yes.
Deposed to by one Matthew Patience. We rely on all the paragraphs of the said affidavit, of the said counter affidavit, my lord.
Yes.
Also, my lord, pursuant to the rules of this honorable court, we also filed our written address in opposition to the claimant's motion on notice.
Yes.
Lord, we adopt same as our argument. In opposition to the written address attached to the said motion on notice. My lord, just by way of adumbration, my lord, what we are saying is that the matter has gone far beyond that, and the amendment intended by the learned counsel is to change the character of the matter, and also it is quite overreaching, having been served with our final written address before filing same. And secondly, my lord, the defendant has right to file a further and better affidavit, which he has not done, and he has been served. You know, I would like to be guided by the record of the court. I know they have been served since we filed this thing, since that 28th.
Further and better affidavits to what?
Maybe to our counter affidavit, my lord.
Did they file a further and better affidavit?
That is what I'm saying, my lord, that they do not file. So, and it is presumed, it is tried that they also agree with what we are saying in our counter affidavit.
Okay.
Thank you, my lord.
Yeah.
We are most
Thank
grateful.
you. Ruling. The claimant commenced this action by complaint filed on the 1st of March 2021, wherein it prayed for order of court directing the defendants to pay his terminal benefits and for other reliefs. The instant motion on notice was filed by the claimant on the 21st of June 2022, by which he sought leave of this court to amend the statement of fact. I had given due consideration to the said application and the facts deposed in the affidavit filed to support the same. The proposed amendments, the proposed amended statement of fact, the totality of the written and oral arguments canvassed by the claimant's learned counsel in support thereof. In the same vein, I had also carefully considered the counter affidavit filed on behalf of the defendant on the 28th of June 2022 to oppose the same, including the written and oral arguments canvassed by learned defendant's counsel to oppose the application. According to the facts deposed in the affidavit filed to support this application, particularly paragraph 3, sub 3 and 4 thereof, the need by the applicant to amend a statement of fact was essentially as a result of the fact that the claimant omitted to state in the initial statement of fact that was filed the amount that was due to him as pension from the defendant, which is relevant to his case. In opposition, it was deposed on behalf of the defendant, particularly in paragraph 3H, I, J, and K of the counter affidavit, that the purpose of the application is to introduce a new relief, which is unsupported by evidence, that the claimant must have discovered the weakness of his case, and that the amendment sought by the claimant is meant to overreach the defendant and in bad faith. The question that the court must determine is whether, on the basis of the totality of the circumstances of the case, and also considering the stage at which the case is reached, it is proper to grant the amendment sought by the claimant. As it is well known, and as adequately converted by counsel on both sides, an application for amendment can be made by a party at any stage of the proceedings before judgment, and a court is determining whether or not to exercise its discretion in favor of granting the application must be guided by laid down principles enunciated and handed down from time immemorial by judicial precedents. The overriding ground for granting an application for amendment is basically to ensure that the real issues in controversy between the parties are brought to the attention of the court for proper adjudication. In All Sam S.A. versus Saraki 2014 Nigeria Weekly Law Reports, past 687 at page 415, the Supreme Court appositely encapsulated the principles for amendment when it held as follows, I quote, in law, to amend any legal process affords a party, whether a plaintiff or a defendant, and even the appellant or respondent on appeal, to correct an error in the legal documents. Amendments enables the slips, blunders, errors, and inadvertence of counsel to be corrected in the interest of justice, ensuring also that no injustice is occasioned to the other party. The weight of judicial authorities leans in favor of allowing a party to amend its legal processes whenever the need arises, in order to ensure that the real matter in controversy between the parties, shorn of manifest errors, mistakes, and slip, is adequately brought to focus and determined, with the proviso, however, that the right of the adverse party is neither unduly compromised or unredressed. The last point that is necessary to be made in this regard is that once the justice of the case so demands, the court can grant an amendment at any stage of the proceedings. End of quote. Also, in the locus classicus case of Oja versus Ogboni, 1976, all Nigerian law reports, part 4 at 146. The Supreme Court held inter alia that the only ground upon which an application for amendments will be refused by the court are where it will entail injustice to the other party, or where the party seeking amendments is acting mala fide, or by his blunder, the applicant has done some injury to the respondent, which cannot be compensated by cost or otherwise. The cases of MBC PLC versus Zubani, Adekeye versus Akinyolugbade, Eze versus NN, Concept Investment Limited and another versus Union Bank, cited by respective counsel, are quite opposite. Now, I have proceeded to examine the substance of the amendment sought by the claimant applicants as set out in the amended statement of facts. They contain facts which, according to the applicant, will be necessary to establish his case, but which facts were inadvertently omitted at the time the initial claim to the suit was filed. The amendment sought is contained in paragraph 21, sub 3. In the instant case, the question is, what prejudices, injury, or injustice will the defendant suffer if this application is granted? It is elementary to state that the provision of Order 26 Rules 3, 1, and 3 of the Rules of those Courts, also correctly referred to by the defendant's learned counsel, the court is empowered to allow a party to amend any defects or error in any process, and all necessary amendments shall be made for purpose of determining the real issues between the parties. It is my view that parties should be allowed to bring to the fore every available fact they consider germane to a just determination of a suit, so long as the rights of the adverse party is not infringed, and so long as it is not shown that the amendment sought to overreach the adverse party. I therefore totally disagree with the submission of learned counsel for the defendant that the proposed amendment is aimed at overreaching the defendant and in bad faith. In my view, the focal purpose of the present application is to afford the claimant the opportunity to put forward all facts available to him, which facts, according to him, were inadvertently omitted when the statement of facts was initially filed, to assist the courts in determining the real issues and controversies between the parties in the suit. It is my further view that more injustice will be done to the claimant if this application is refused, as his rights to fair hearing will not have been seen to have been protected. On the other hand, whatever inconveniences caused the defendant by the application could always be redressed by filing a consequential amendment or compensated in cost. Ultimately, the focus of the course is to ensure that it is seen that justice is even-handedly served to all the parties at the end of the day. In the final analysis, I find merit in this application, and the same shall be and is hereby accordingly granted. Leave is hereby granted to the claimant to amend the statement of facts. It is further ordered that the amended statement of facts shall be deemed as duly filed and served.
As the court pleases.
As the court pleases.
My Lord, we are so grateful for my Lord's well-considered ruling. We are ready to adopt our final addresses if the other counsel is also ready.
Yes, Mr. Ibrahim.
My Lord, we are most grateful. We are also ready, my Lord.
Yes.
The defendant starts.
Yes, you can. The defendant, where's your address? You start first, I believe.
Very well.
Yes, my Lord.
You were not hoping that you will adopt, so you're not ready for this morning?
We are ready, my lord.
Yes, you can
We are
proceed.
equally ready. My lord, the defendant filed a final written address dated dated 14th day of April 2022.
When was it filed?
And filed on the same date, my lord.
14th of what?
And dated 14th day of April 2022, and filed on the 20th day of April 2022.
Just a moment, let me look for it in my file. It was filed on the 20th of April.
It was filed on the it was filed on the 22nd, my lord, based on the
well, I have 20th, 20 on
yes,
my
it's
own
20th. Yes, it's 20th, my lord. It's 20th. I'm so sorry.
Yes.
My lord, we humbly adopt our final written address as
Yes.
the final submission of the defendant in respect of this case. And we humbly urge this honorable court to enter judgment in favor of the defendants.
Yes, Mr. Lagan.
My lord, just by my lord, with the kind permission of this honorable court, just by way of a little adumbration.
Very well, you can proceed.
Okay, thank you, my lord. So we have been able to raise just one issue for determination, which
Yes.
is whether from the evidence before the honorable court, so and proper consideration of all the exhibit tender, the claimant is entitled to these claims. And we argue the said issue, my lord. Our main concern is that before the claimant can be entitled to all the relief sought, they need to bring before this honorable court the basis upon which those reliefs are being sought.
Okay.
So generally speaking, my lord, the relief sought by the claimants are based on speculation. We have cited
based on what?
Speculation, my lord.
Okay.
So, and we have cited various authorities, plethora of authorities, on the fact that it is right that court of law does not act based on speculation.
Yes.
So, in view of that, we humbly urge this honorable court to enter judgment in favor of the defendants and dismiss the case of the claimants. We are most grateful.
Okay. Thank you. Mr. Lagan?
Yes, my lord. On behalf of the claimant, we've filed a written address, which is dated and filed 17th day of June, 2022.
Yes.
My lord, we must humbly adopt all the arguments contained in this written address as our submission in support of the claimant's claim before this court.
Yes.
My Lord, we have adequately, to the best of our ability, put in the facts, the law, and the evidence before the court in our address. I wouldn't need to belabor my Lord with any adumbration, only to add that it is a court of law and court of equity, a court of justice, that will look at the entire circumstance of this matter and same be determined in favor of the claimant. That is our prayer, my Lord. We ask that the court enter judgment in favor of the claimant and grant the relief sought. Thank you so much, my Lord.
Thank you. Court case is adjourned to 26th of October 2022 for judgment.
As the court pleases.
As the court pleases. My Lord, 26.
26 October.
Okay, as the court
For
pleases,
judgment.
We are most grateful, my Lord.
Thank you. Yes, the next case, please.
Case number 2, NICS/KD/27/2020 between Adukadia Ado Yusuf and Nikon Insurance Limited. My Lord, parties absent.
Appearances, please.
Respectfully, my Lord, C.O. Adu. Adu is spelled A-D, my Lord.
A what?
A-D.
ADU.
Yes, my Lord. I'm appearing for the defendant applicant.
Your appearance is for who?
Defendant applicant.
Okay. Any appearance for the claimant?
No, Lord. We complain we had a matter before another court.
Ruling. The claimant commenced the present action by complaint and statement of facts filed on the 26th of August 2020, by which he claimed for remittance of his entitlement, the defendant had allegedly failed to remit into his retirement savings account. However, upon being served with the originating processes in the suit, the defendant filed the present notice of preliminary objection on the 7th of February 2021 to challenge the competence of the suit and the jurisdiction of this court to entertain the same on the grounds set out as follows. 1, that the court has no jurisdiction to entertain this suit as composed, as the claimant has no locus standi to maintain the action. The proper claimant is the National Pension Commission. 2, the suit is an abuse of court process, as the National Pension Commission has filed a suit marked as suit numbers NICN/ABJ/63/219, that is National Pension Commission versus Nikon Insurance PLC, pending before the National Industrial Court, Abuja. The objection is supported by a 6-paragraph affidavit with 1 document attached as exhibit. Also filed alongside is the Learned Counsel's written address. In reaction to the preliminary objection, the claimant filed a 4-paragraph counter affidavit on the 1st of December 2021, with one document attached as exhibit, and the written address of his Senate Counsel, Aruna S. Usman Esquire, was filed alongside. I have carefully considered the totality of the processes filed on both sides to support and oppose this instance objection. I had also taken cognizance of the totality of the written and oral arguments of learned counsel on both sides, to which I shall specifically make reference as I consider needful in the course of this ruling. It is not in dispute that the claimant was an employee of the defendant until he resigned his appointment on the 17th of September 2014. There is also no contention that the defendant is a company incorporated in Nigeria, engaged in the business of insurance services, providing same to the individual and corporate customers. The claimant's grounds is that in spite of several demands, the defendant had failed to remit his pension to his retirement savings account. The contention of the learned defendant's counsel, S.B. Mohammed Esquire, in his objection is that the claimant has no local standing to institute the action for a claim of remittance of pension, that the claimant has no proxy with the past and present members of staff of the defendants, and that the proper body that has the capacity to sue for non-remittance of pension of members of staff of the defendants is the National Pension Commission. On the issue of abuse of court process, learned defendants counsel argued that as the proper party to claim for remittance of members of staff of the defendant, the National Pension Commission had instituted a suit in Abuja Division of National Industrial Court in suit number NICN/ABJ/63/2020 in National Pension Commission versus Nikon Insurance PLC, that the claim was instituted on behalf of the present and past members of staff of the defendant, including the claimants in the institute. Learned counsel argued further that both the case pending at the Abuja division and the present case relates to the same parties and subject matter. Learned counsel finally urged the court to hold that the present suit as constituted as an abuse of court process. To determine whether or not a court can exercise jurisdiction over a matter, it is settled that the court is required to examine the facts averred in the statement of facts and the reliefs endorsed therein. See the cases of FUMB Limited versus Aerobel Nigeria Limited, Moyosora versus Governor of Kwara State, Guinness Nigeria PLC versus SKA Nigeria Limited. Citations also applied. So as it is in this case, the court must restrict itself to the facts averred by the claimant's statement of facts in determining the issue of jurisdiction. Now, the factors or principles which usually guide the courts in determining the locus of a party to institute a suit are more or less commonplace and have been laid down in a long line of judicial authorities from time immemorial. It is, however, pertinent to underscore the point and restates that the dominant factor that determines a party's competence or capacity or standing to institute an action is that the party, as the claimant, must show by his claim before the court that he has sufficient legal right or interest in the subject matter of a suit, which legal right or interest has shown to have been or in danger of being violated or invaded or adversely tampered with by the alleged acts or intended acts of the defendant, which legal right the court is entitled to protect by virtue of its power under the provision of Section 6(b) of 1999 Constitution as amended. See the well-known authorities of Adesanya versus President, Federal Republic of Nigeria, Thomas versus Olufosoye, Owodiomi versus Registered Trustees of Celestial Church of Christ, Yusufu versus Governor of Edo State, Pam versus Muhammad, and Attorney General Delta States versus Asen. Citation also applied. Therefore, where a party standing to commence an action is challenged or in issue in a matter, The focal question to be resolved will be whether the person whose standing is an issue is the proper person to request the adjudication of a dispute, and not whether the dispute is justiciable or meritorious. See also Okoye versus Lagos State Government, 1990, 3 Nigeria Weekly Law Report, Part 136. As can be gleaned from the affidavit evidence filed by the defendant to support this objection, the facts upon which the defendant predicated its contention that the claimant lacks the locus standi to commence the present suit is essentially based on the averment of the claimant that the defendant had failed to remit his pension to his retirement savings account with trust fund. According to the defendant, the National Pension Commission is the proper party to make claims for remittances on behalf of the members of staff of defendants, and the claimant cannot institute the case not being proxy of other members of staff. On the basis of the facts relied upon by the defendant, could the claimant be held to lack the locus to institute the suit? The answer to the poser is an emphatic no. The submission of learned defendant's counsel that the claimant has no locus to file the instant suit is clearly misconceived. The instant suit is within the realm of individual labor dispute, and the claimant has the right to sue the defendant as its former employee. See the case of Olutomilayo versus Attorney General Federation, 2015, 62 Nigeria Labor Law Report, Part 217 at 254. It is also settled that the right of the claimants to pension is a constitutional right guaranteed under the 1999 Constitution of the Federal Republic of Nigeria as amended, and anyone entitled pension can claim it as a matter of right. The right to sue for remittance of pension by an individual as a claimant in the instant suit is not exclusive or limited to the National Pension Commission, as erroneously submitted by learned counsel for the defendant. On the basis of the brief facts as averred in the statement of facts, I am satisfied that the claimant has sufficient interest to have entitled him to commence the suit and to seek reliefs against defendants. Therefore, the submission of learned defendant's counsel that the claimant has no locus for his claim for remittance of his entitlements from the defendant is baseless and unsustainable, and I so hold. The reaction of the claimant on the issue of abuse of court process is that the claim of National Pension Commission, that is PENCOM, in the suit filed in Abuja does not only capture his claims against the defendant, that he did not request or instruct PENCOM to institute an action on his behalf, and that he will be prejudiced by including his claim with the pensions case. The argument of learned claimant's counsel is that the PENCOM case does not adequately capture the whole of the claimant's claims. In the instant case, the claimant's claims for unremitted retirement savings for the periods between 2009, 2010, 2011, and 2013, and B, February to March, May to December 2012, and C, January to September 2014, whilst the claim by PENCOM on behalf of members of a staff is for unremitted savings for 2006 to 2012 only, citing the cases of Ukagba versus others and others versus Ugojin and others, and the case of Bello versus Fayoshe, citations supplied. Learned counsel for the claimant submitted that by including claimants claiming PENCOM claims without his consent or instruction, the claimant had been robbed of his constitutional right. Learned counsel further argued that the instant case was initially instituted in 2015, that the said case was dismissed on the 26th of July 2017, that the order of dismissal was reversed to striking out an appeal, and the instant suit was subsequently filed on the 26th of August 2020, I beg your pardon. According to learned counsel, the present action is a continuation of the earlier case that was struck out, and as such, instituted before the Pencon's case filed in 2019. To buttress his argument, learned counsel referred to Exhibit A attached to the counter affidavit and the case of Panapile World Transport Nigeria Limited versus J.B. Olandin International and others. 2010 Law Pavilion Electronic Law Reports at 2902. Now, the law is well settled that the issue of abuse of court process is an issue of jurisdiction, and like all issues pertaining to ones of jurisdiction, it can be raised at any time, and it can be raised as a complete defense to challenge the competence of an action or jurisdiction of the courts to entertain same. See the case of Kashum versus Attorney General Federation, 2013, Law Pavilion Electronic Law Reports at 22357. It is also tried that the concept of abuse of court process is imprecise. It involves circumstances and situations of infinite variety and condition, but a common feature of it is the improper use of judicial process by a party in litigation to interfere with the due administration of justice. See the cases of Ujo versus Attorney General Shio State, First Bank PLCs versus TSA Industries, and NDIC versus UBN PLC citation also applied. Essentially, the circumstances under which a process of court is used or employed or for what purpose determines whether or not such a process constitutes an abuse of court process. When abuse of court process is said to occur, it exhibits a situation where a party has irritated a court process with a clear lack of bona fides, leading to the annoyance and irritation of the other party with the aim to overreach with attendant results of having the court itself directly vexed and to circumvent the efficient and effective administration of justice. An abuse of court process could be said to have occurred in one or more of the following situations. One, where the parties, subject matter, and the issues in the previous and the latter suits are the same. Two, where different actions based on the same facts between the same parties are filed in different courts or even the same courts simultaneously in respect of the same right and subject matter. Three, where a party litigates again on the same issue which has already been litigated upon between him and the same persons on facts on which a decision has already been reached, where the proceeding is wanting in bona fides or is frivolous, vexatious, oppressive, or amounts to abuse of legal procedure or improper legal process. The question now is whether, on the basis of the facts as set out in the statement of facts, can it be said that the instant suit had been caught by any of the applicable instances of abuse of court process for the proceedings to be halted by the courts? By the facts as deposed in the counter affidavit in opposition to the preliminary objection, it is not in dispute that a case instituted by PENCON on behalf of its staff, including the claimant in the present case against the defendant, is pending before the Abuja division of those honorable courts. It seems to me that in order to determine the issue of abuse, a critical look should be undertaken of the causes of action in the two suits and the reliefs claimed in order to determine the correlation between the parties in the suit and those in the instant suit. I had proceeded to undertake this exercise. It is clear to me that the principal relief claimed in suit number NICN/ABJ/63-219-2019, that is National Pension Commission versus Nikon Insurance PLC, is largely for remittances of outstanding pension contributions of the claimants, that is PENCOM, employees or beneficiary, is for the years spanning from 2006 to 2012. PENCOM is also seeking the leave of court to impose penalty against the defendant for late remittance of pension contribution for the same period of time. Now, by the instant suit, the claimant claims the total sum of money being his retirement savings contribution to the defendant for a period spanning from 2009 till September 2014, and for premium of 2% per month on the paid contribution from the date of filing of the action until judgment is delivered. Essentially, in my view, present suit is likely between the claimant and the defendant, whilst the other case is between PENCOM as a regulatory body and the defendant. The contention of the defendant is that the claims of the claimant in the instant case for his unremitted contribution is subsumed in the claim made by PENCOM on behalf of its member. Now, upon a comprehensive analysis of the reliefs claimed in the two suits, the parties and the causes of action, the salient questions that readily assail my mind are: one, will it be said that the present suit constitutes an abuse of action pending in suit number NICN ABJ/63/2019, that is the Abuja division of this honorable court? Two, is it possible that the present suit can be determined independent of the action pending before the Abuja division of this honorable court? Three, could the outcome of the present suit overreach the decision that could be reached in the action pending before the Abuja division of this honorable court? Four, does it appear that the present action is filed in bad faith with the intention of annoying or irritating the defendants in the suit pending before the Abuja division of this honorable court? In my respective view, whilst answers to questions 1, 3, and 4 are in the negative, the answer to question 2 is in the affirmative. I disagree with the contentions of the defendant's learned counsel that the reliefs being sought by the claimant in the instant suit is the same relief being sought in the PENCOM case. This is for the reason that the causes of action in the two suits are radically different and may not be conveniently accommodated in the same suit, particularly since the years of unremitted contribution of the claimant is not covered by the reliefs being claimed in the PENCOM case, and are so hold. As rightly submitted by learned claimant's counsel, Exhibit A attached to the counter affidavit was a letter written by the claimant in 2016 to request from the defendant for the computation of penalty and his entitlement that may be due to him for non-remittance of his pension contribution to assist in making his claims that was at that material time pending before the Kano division of this honorable court. I am of the view that PENCOM was fully aware of the claimant's case pending before the court when it filed another case on behalf of its members of staff in 2019. I must completely agree with the claimant's learned counsel that this present action does not constitute a case of abuse of judicial process. Without any much ado, therefore, the defendant's objection is hereby accordingly dismissed. The cost of 100,000 naira only is awarded against the defendant.
As a court. My lord.
Yes, case is adjourned to the 18th of October, 2022 for hearing.
That was good.
Hearing notice shall be issued and served on the claimant. Court case is adjourned to the 18th of October 2022 for hearing. Hearing notice shall be issued and served on the claimant. Yes, the next case, please.
Case number 3, NICN/KD/39/2020 between Hassan Shehu Ahmed and Famax British School. My lord, parties absent.
Parties absent, appearances, please.
With profound humility, H.T. Oyebanji, my humble appearance for the claimants, my lord.
Judgment.
As follows.
The claimant initiated the present action by a complaint and statement of facts filed on the 10th of November 2020. His case in a nutshell is that in spite of several demands, the defendant had neglected, refused, and/or failed to pay the arrears of his salary. The claimant's grievance against the defendant is further that he properly earned a salary as a deputy class teacher of the defendant until he voluntarily resigned his appointment, but his monthly salary was paid only twice throughout the period he served. The claimant alleged that he has suffered untold hardship by the defendant's refusal to pay his arrears of salary. Whereof the claimant's claims against the defendant, the relief set out as follows. The relief is as stated on the face of the judgment. I'll skip it to save the time of the court. It is borne by the record of proceedings in the suit that the defendant was duly served with the originating processes and hearing notices for the scheduled hearing dates. It is equally borne by the record of proceedings that in spite of the several hearing notices issued and served on the defendant, there was never any representation by counsel or any process filed in defense of the suit. The claimant at the trial testified in person and called no other witness. He adopted a statement on oath and tendered in evidence a total of 6 documents as exhibits to establish his case. In view of the defendant's failure to file defense to the action, the court ordered the filing of written addresses as prescribed by the provisions of the rules of this court. Expectedly, only the claimant filed a written address on the 4th of April 2022, in which his learned counsel, H.T. Oyebanji, formulated a sole issue for determination, that is, whether or not from the totality of all evidence adduced before this honorable court, the claimant has been able to prove his case premised on a document that lacked genuineness and authority. In my view, and considering the uncontroverted evidence laid on the record, the only issue arising for determination in the suit could be reframed as follows: whether or not the claimant established credible evidence to entitle him to the relief he sought in the suit. It says tried law that the net effect of the failure of a defendant to file pleadings and call evidence in defense of the claims against him at the trial is that the assertion of the claimant in his pleadings stand unchallenged and are deemed admitted and established. See the case of Consolidated Resources Limited versus Abofar Ventures Nigeria Limited, the case of Okoli versus Mariho, and the case of Bauchi State Government versus Gumal Sectional Supply. It is all equally settled law. The failure of the defendant to defend the case cannot mitigate the duty of the claimant to prove his claim by credible, sufficient, and admissible evidence. The claimant is to succeed on the viability and strength of the case he made out on both pleadings and evidence, and not by the mere absence of a defense to the claim he made against the defendant. See the case of Aka Hair Services Limited versus Kiaso and Ogunyade versus Oshukaya Citation Supplied. The claimant testified in person as CW1, and his letter of offer of appointment dated the 2nd of January 2018, containing the terms and conditions of service, was admitted in evidence as Exhibit C1. His further testimony is that His basic monthly salary was explicitly stated as 89,500 in Exhibit C1, and that he properly worked to earn a salary as a deputy class teacher, but that he was paid only twice throughout his employment until he resigned his appointment. The claimant also testified that a demand for payment of arrears of salary made by himself and other members of staff was misconstrued by the management of the defendant, and that the defendant issued a notice to all members of staff. The said notice issued to members of staff was admitted in evidence as Exhibit C2. The claimant further testified that due to the failure of the defendant to pay his arrears of salary and in compliance with the defendant's notice in Exhibit C2, he tendered a notice of resignation of his appointment. The notification of resignation dated the 29th of June 2018 is admitted as Exhibit C3. The claimant also testified that he engaged the services of solicitors to make formal demand, and that thereafter one Hassan Ibrahim, the legal advisor of the defendant, demanded for a meeting to resolve the matter, but the defendant did not reach out to him since the meeting was brokered. The letters of demand dated the 14th of October 2018 of Sani Mohammed Kuso and Co. and Biolo Yebanji and Co. were admitted in evidence as Exhibit C4 and C4A. I have undertaken a calm assessment of the evidence adduced by the claimant. As revealed by the documentary exhibit, the claimant's monthly salary is 89,500 naira. The unchallenged evidence is further that throughout his employment, the defendant paid only 2 months' salary, and that in spite of several demands, the defendant had failed to pay his salary until he resigned his appointment. The law is tried, as correctly submitted by Learned Counsel for the claimant. When parties enter into a contract, they are bound by the terms therein. The terms and conditions of claimant's employment, as concisely reduced in Exhibit C1, are precise. The testimony of the claimant deducible from Exhibit C1 and C3 is that he was employed on the 2nd of January 2018 and that his salary was paid twice. By Exhibit C2, the defendant had set the 29th of June 2018 as the date of resignation of members of his staff who intends to resign their appointment from the services of the defendant. The claimant also testified that on that premise, it tendered his letter of resignation of appointment on the 29th of June 2018 to be effective from August 2018. In the present case, in the absence of the defendant adducing any evidence whatsoever, the imaginary scale on the defendant's side remained weightless and unable to tilt the proverbial scale, which clearly was heavily laden in one direction, to wit, on the side of the claimant. In such a situation as in the instant case, where material evidence given by a party to any proceedings was not challenged or rebutted by the opposite party who had the opportunity to do so, the court is open to act on such unchallenged evidence before it. Therefore, I am satisfied that the evidence adduced by the claimant on the non-payment of 5 months' arrears of his salary by defendant is credible and sufficient to sustain its claim in law, and as so holds. On the basis of the uncontroverted evidence on record, therefore, the claimant is entitled to unpaid salary of 5 months from March 2018 to July 2018 at the rate of 89,500 naira per month. And I so further hold. In the final analysis, the claimant's claim succeeds in part for the avoidance of doubts in abundance of clarity. Judgment is hereby entered in the following terms. 1, an order directing the defendants to pay to the claimant the sum of 447,500 naira, being the total amount of unpaid salaries due to the claimant. 2, an order of this honorable court directing the defendants to pay the said sum of 447,500 naira within 1 month. And 3, 10% interest on judgment sum from date of judgment until judgment is liquidated. I make no order as to cost. So the only relief I did not grant is on the relief on the damage you did not prove, which was not adequately proved. So that is the judgment of the court.
As a couple, we applaud my lord's well-considered ruling. Remain most obliged.
Thank you.
Yes.
The court will now rise.